Welcome to Conversations from the Mesa, and thank you for joining us. It is an absolute privilege to have the Honorable Troy Eid presenting for the Mesa Verde Foundation. Troy is deeply respected across Indian country and its communities for upholding tribal sovereignty, ensuring state governments, administrations, and Congress are held accountable. As a Cherokee Nation citizen, it is an absolute honor for me to serve on the Mesa Verde Foundation's Board of Directors with Troy and personally witness his unwavering leadership, as well as his professional and personal achievements, not to mention all the good he puts into existence. On this webinar, Troy will discuss tribal consultation. What is it and how does it affect Mesa Verde and other national parks? He will give insight into the origins of tribal consultation and how it applies in practice at Mesa Verde and beyond. Troy co-chairs the American Indian Law Practice Group at Greenberg Traurig. He is the president of the Navajo Nation Bar Association, which is the largest legal services organization in the country that directly serves a Native American tribal government. Troy is the former United States Attorney for the District of Colorado, appointed by President George W. Bush. During the Obama administration, Troy chaired the Indian Law and Order Commission, the advisory board to the President and Congress for strengthening public safety for all 574 federally recognized tribes. He was named the 2022 Lawyer of the Year in Colorado by Best Lawyers in America and is ranked as one of the nation's top 10 experts in Native America law, the latest Chambers USA guide. Before I welcome Troy, I would like to quickly mention a few Mesa Verde Foundation updates. The foundation is currently hosting our third annual virtual fundraising auction. Everyone is invited to participate. The auction will end this Saturday, May the 14th. The Mesa Verde Fall Tour is back. This 4-day VIP tour offers a behind-the-scenes, in-depth experience led by historian Dr. Andrew Gilliford and Zuni tribal member Christopher Lewis. If you would like more information, please visit our website. This webinar series will be taking a hiatus this summer. We would like to invite you to experience Mesa Verde National Park in person while the weather is still gorgeous. We will return with more content in September. Without further delay, it is my absolute pleasure to now welcome Troy.
Well, thank you, Director Buckle. Monica. And in all seriousness, thank you for all your leadership in Indian country and around the nation in fine arts, and your career has been an inspiration, and appreciate the chance to get to work with you in the Mesa Verde Foundation effort, and it's wonderful to be here. So thank you for your gracious words. I thought somebody had maybe died, maybe me.
No, no, not at all. I promise you, you're in the here and the now.
I'm still here, so.
Yes.
And Shannon Clifford, thank you for your great leadership. You've been a tremendous influence on so many of us and doing a wonderful job for the foundation, and salute you. So
thank you, Troy.
A bit about tribal consultation today, and I'm going to share some slides here in a second, so hang on a second while I figure out how to do that. All right. The scene of Mesa Verde in the winter, if you've not ever seen the Candelarias, it's just the most beautiful setting. You're up on the rim looking at Spruce Tree House and looking down through the snow and the candles lighting up the ancestral Puebloans' homes. It's just a magical, mystical sight. So again, my name is Troy Eid, and I'm so pleased to be with you. I'm vice chair of the board. I've been a member of the board now. It's my 10th year, and I'm very honored to be here, especially with Monica, and looking forward to this conversation. We're going to talk about tribal consultation, but the way to get into it is to understand first principles. Our Constitution is the base, and yet so many of us, even those who might look back to our high school or our junior high that was a thing for me, but middle school for maybe the rest of you, classes, we didn't necessarily learn about the fourth sovereign. We learned about the fact that the Constitution recognizes three sovereigns, of course, the federal government it creates with the consent of the people, the states that came together in a constitutional convention with their representatives and delegates to create the Constitution, so those sovereign states. And then, of course, foreign states, as they're called, or foreign nations. They're all in the Constitution, but we sometimes don't know or have forgotten, perhaps, that tribes are, as I'll talk about, explicitly referred to in the Constitution. And tribes' rights predate the Constitution, as tribes' lands do, because they were here since time immemorial. And so we're going to talk about this concept of what has become tribal sovereignty. That's the modern term for this. Tribes' rights are inherent. That is to say, these were self-governing polities or political organizations, governments for people, long before there was a United States, long before there were the British Crown colonies or the areas that France controlled or Spain controlled in the quote-unquote New World. These tribes were here. Their rights continue inherently, and they will continue as long as Congress does not change them. We have this concept in what I'll describe as Indian law, and I'll explain the terminology here, but we call it Indian law in the terms that Congress uses, Indian law, and I'll explain that in a second. But the concept is that these self-governing societies continue, but that Congress has the ultimate authority over them because they're part of the United States now. They become part of and absorbed within the United States. And for that reason, as we'll discuss, there's another premise to all of this, that state laws, the laws of the sovereign states, don't apply presumptively to tribes unless Congress has somehow said that they do. So we have a federal relationship with tribes with inherent rights that predate our Constitution. And something we call federal Indian law. What is this term? When you take a class at most of the law schools that teach this, it's called federal Indian law. And I teach this at the University of Colorado School of Law and also at the University of Denver Sturm College of Law. I teach a course called federal Indian law. There are 574 federally recognized Indian tribes in the United States. And of those, 327 have permanent homelands in what we call federal trust status that totals about 60 million acres. Now, we refer to this in the lower 48, especially as the reservations, Indian reservations. And yet that term is also a misnomer in the modern era. Often we think that somehow the federal government reserved land for tribes, but that's not what happened. Historically and legally, tribes reserved lands to themselves. Typically what happened was that tribes had a much larger homeland when the United States came into being. And as white settlement, non-Indian settlement occurred, forced cessions of lands, a cession being maybe a forced sale, sometimes outright confiscation, often at the end of a barrel of a gun. The forced cession of these lands meant that tribes gave up most of their land, but they also, in exchange for that, got two things. One was often a reservation of their own. They reserved some land for themselves, which the US government then recognized, the federal government recognized in the old days through treaties, as I'll describe. And the other thing was that they could retain their self-governing status unless the US Congress had somehow limited that or did limit that over the years. And so tribes continued to operate as they always had according to their own laws. And that continued and to a great extent continues to this day over tribal members, as we'll discuss later in the presentation. So there are roughly 327 Indian reservations in the lower 48. There are 326. There's one in Alaska called Metlakatla Island. Not all tribes have reservations of land. Some gave up land, but they either didn't obtain a reservation of their own land that was recognized by the Congress, or they lost land later. Congress took lands away from them. The classic example is Alaska. In 1971, Congress enacted the Alaska Native Claims Settlement Act, and the tribes in Alaska, and there are 229 that are federally recognized in Alaska. That's where the vast majority of the tribes in terms of geography are located as a big block. 228 of the 229 lost their lands. So as governments, they no longer have reservations of land to themselves. Congress took that away. Congress has this, as I'll discuss, what's called plenary power, an absolute power over tribes. And we'll talk about how that came to be. But in 1971, when ANCSA, which is the slang for the Alaska Native Claims Settlement Act, was enacted, at that time, a different system was set up in Alaska. Rather than what we see in the lower 48, where tribes have reserved some land to themselves and they have the rights to self-govern that. In Alaska, they lost their lands as governments, but a new system was set up by the Congress where individual Alaska Native people were afforded shares, like they were corporate shareholders, shares in land that was set aside for them, and then divided regionally into a series of regional for-profit corporations. So 12 of them in Alaska divide up another 45 million acres of land. And in many cases, these regional corporations have diversified and in some cases have thousands of employees. They do business all over the world, not just in Alaska, not just in the United States. And so they've taken their resources, oil and gas and timber and commercial fishing and on, and they have diversified those resources. And there are dividends that can be paid to the descendants of the tribal members there. There's still, those members still have recognition as tribal citizens with their respective governments, but their governments are landless. And as individuals, they receive payments from the lands that were set aside by ANCSA starting in 1971. I believe ANCSA has been amended more than 30 times, so it's a very complicated law and the source of perhaps another webinar, maybe not from Mesa Verde Foundation, but I'd be glad to discuss any of these points with you. You can shoot me an email, you can let Monica know, you can let Shannon know, or just find me on the internet. So I'll be glad to respond to you and answer any questions and engage you on any of these topics. This last point of the slide is important because overall in the United States, American Indians and Alaska Natives were just under 3% of the US population in the 2020 census. They were 1.7% back in the 2010 census. That is an 86.5% increase. Far and away the most rapid growing ethnic or racial group in the United States is the group defined, self-identified in the census as American Indians and Alaska Natives. The term federal Indian law then, what is this? Well, that term refers to the thousands of treaties, the congressional statutes, presidential executive orders, and federal court decisions, and there are thousands of those, by which the US government defines its relationship to the tribes and the legal and political status of tribes within our federal system. And that includes the recognition of tribes' inherent sovereignty as governments predating the Constitution. So in the words of the late great senator, a good friend and mentor to me, the Honorable Daniel Inouye of Hawaii, distinguished World War II veteran who passed in 2012 and chaired for many years the US Senate Committee on Indian Affairs, quote, "The sovereign status of Indian nations is the fundamental premise upon which a course of dealings between the United States and Indian tribal governments ensued, and the foundation upon which hundreds of federal statutes and thousands of federal court rulings have been based." Think about that phrase, course of dealings. Every time there was an interaction, it would be typically with a single tribe. And so often prior to 1871, when treaties were made with tribes, Congress abolished that practice in 1871 in legislation that is of dubious constitutionality. Again, topic for another webinar. But prior to 1871, the US government entered into treaties with individual tribes. And so the course of dealings might be between a single tribe and the US government, or it might be in a region with several tribes. The point is that that course of dealings is defined through different legal documents, and that whole body of law is federal Indian law because, again, the states presumptively don't have these relations with the tribes. The US government does. And so what does our Constitution really say about Indians, about tribes? And again, these terms, when I say Indians, this is the term Congress uses in statutes. It's also the term the Constitution uses, and so I'm using it as a legal term. And tribes is the term that's also used in the Constitution. So in terms of Indians in the Constitution, Constitution was ratified in 1789. And so right out of the gate in Article 1, Section 2, the section dealing with the legislative branch of government, when we speak of apportionment of the House of Representatives within the sovereign states, who's going to represent them in the U.S. House of Representatives, the apportionment formula is the first place we see the word Indian. And the language is in Section 2, quote, the House of Representatives shall be apportioned, and it talks about the several states that'll be included within this union, that may be included. Notice that they were already thinking about adding additional states. And every time that happened, that would be indigenous land that was taken away, and again, typically by forced coercion, and became a state. So as the Supreme Court often described in the early 18th century, the states were the, quote, natural enemies of the tribes, because every time a new state came in, it was at the expense of the tribes that were there, was the typical formula. The House of Representatives will be apportioned according to their respective numbers, which shall be determined by adding the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 all other persons. Now, we all today know about the 3/5 clause, I think, or what that means. This was a compromise, largely at the behest of James Madison and the Southern advocates of the Constitution. They were not, of course, recognizing enslaved African Americans, Black people, as anything other than property in that era. They were not viewed as human beings according to their perception and their laws. But they were counted in our Constitution as 3/5 of a person for whether the Southern states would get representatives in the U.S. House. So it was a built-in subsidy, if you will, for Southern representation of slaveholding states. Very notorious, and we'll come back to the 3/5 clause. And we also, I think many of us, or most of us, have studied that at some point in high school, or maybe earlier, or even in college or graduate school. But we often don't see that phrase before it, which says excluding Indians not taxed. Well, why does that even exist? Well, Indians were not presumptively included in the Constitution, right? They were citizens of other nations, of tribes. And so they were not part of this bargain that was struck. So the concept of the consent of the governed does not include Indians in the United States. They're the only class of citizens that we have that got their citizenship not by the Constitution, but by statute. It was not until 1924 that all, quote unquote, Indians in the US received their US citizenship by an act of Congress, commemorating the 100th anniversary of the Bureau of Indian Affairs, incidentally, of all things, so-called Indian Citizenship Act of 1924. Why does it say not taxed? Well, because if an Indian, a Native American person of that era, had, let's just say, moved to a city like Philadelphia or Charleston, or one of the cities in the original 13 states, that person was no longer in what had been recognized in the term that Congress calls Indian country, was not in an area where there were tribes. And so if they came into the jurisdictions of existing states that were already subject to state law, then they were subject to those laws. They were off any kind of a reservation. They were outside of Indian country. And so they would be taxed like all other citizens were taxed. Taxes were more equanimous than the apportionment of representatives was. But the concept of excluding Indians not taxed is significant in Article 1 because you understand the concept of consent of the governed, but understand Indians were never included in the vision of the United States. They were something else. They were other citizens of other sovereigns. We fought a civil war from 1861 to 1865. And at the end of that, we had the so-called Reconstruction Amendments, 3 amendments, and one of them, of course, is the 14th. And that deals with the due process, equal protection clauses of our Constitution, the 13th having abolished slavery. But it states in that language, which again refers to reapportionment, we have a revision. Representative of the House shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. So now we're going to count everybody. We're counting Blacks, African Americans, not as 3/5 of a person, but as a full person, because they have their citizenship now. And remember that earlier the Supreme Court had ruled in the notorious case of Plessy versus Ferguson and Dred Scott before that, that African Americans who were enslaved were not citizens, they were merely property. Well, the Civil War reversed that, and the Reconstruction Amendments changed that. But for the purposes of this webinar, the language relating to Indians did not change and has not changed to this day. Indians are still not in the Constitution. There was a chance to include them. It was discussed, but it never happened. So even after fighting a civil war, even after 1868, if a Native American was living outside of state jurisdiction somewhere in Indian country, in areas that had not yet become states, or on reservations of land that were not part of states, and they were not therefore not taxed, then they were not counted for the apportionments of U.S. members of the House, and they couldn't vote in federal or for that matter, state elections. If we look at Article 1, Section 8 of the Constitution, we also see that Congress, the legislative branch, shall have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. So there you see Indian tribes as a status, a defined polity or legal status that's different than the states and different than foreign nations. And this is very important because this is the basis by which Congress derives its power over tribes to do things like recognition and termination that I talked about earlier. It comes from the so-called Indian Commerce Clause. And then we see that the president in Article 2 has a treaty power. And it doesn't say that it applies to tribes, but in that era, presidents all the way until 1871 made treaties with tribes. That was the standard approach that our government took. And so, unlike the Articles of Confederation that predated the Constitution, they blew apart largely. There were many problems, the taxing power being a huge issue, the lack of a central taxing authority. But the other thing was that under the Articles, each state would have its own relations with tribes. States would make treaties with tribes. And there was vast warfare and bloodshed as a result of the inconsistent policies of the states, which were promoting typically vigorous expansion of their borders. You can think about in that era, the state of West Virginia, or of Virginia rather, went all the way to the Pacific Ocean. And that was true with most of the southern states as well. The boundaries were not established. And so as fast as they could settle, they settled. So there was going to be conflict. And so part of the Constitution was to make that a federal responsibility and to take it out of the control of the state governments. So this is where we start to head into consultation. I talked about the status of Indian tribes. They reserved some land because they were forced, typically at the end of a barrel of a gun or through other forms of coercion. They were forced to cede land, to give up land, to sell land, and so on. But from the very earliest days of our country, the requirement from the Congress and the courts was that Indians could only sell land to the federal government. They could not sell land to private persons. And so this is a bedrock principle to this day. And that's why you have one buyer of Indian lands. And these days it's still the Congress when it comes to acquiring land from tribes. And so keep in mind that as tribes ceded land or gave up land rights, the federal government was supposed to protect them. That's called the trust responsibility. And the Chief Justice, who I talked about, John Marshall, who really mapped this out in the early days, described it this way in Worcester v. Georgia, one of the three foundational cases of federal Indian law. The relation is that of a nation claiming and receiving the protection of one more powerful, not that of individuals abandoning their national character and submitting as subjects to a master. This, again, it's like France and Monaco, or the Vatican in Italy. So as part of that responsibility that we call the trust duty or trust doctrine, the trust responsibility to the 574 Indian tribes, it's how many are federally recognized today. The numbers varied a lot over the years, and it's now at an all-time high in terms of federal recognition. The United States must consult with Native nations on a government-to-government basis. This is the basis for tribal consultation. And so what does that mean? Now we start to become practical. Well, what are you talking about? Well, in this country, if you have a project that needs federal approval, a permit, some kind of federal review, maybe it's compliance with something called the National Environmental Policy Act, where you look at the effects of federally approved actions on the environment. NEPA, that's the statute that many have heard of. This is a picture I took of a pipeline project that I worked on in northern Nevada called the Ruby Natural Gas Pipeline that delivers natural gas from Colorado and Wyoming primarily to the West Coast, primarily California. It's the foundational pipeline these days, one of three that supports their transition, long-term transition to renewable-based energy. These natural gas pipelines, Ruby being the largest 54-inch diameter pipeline. You need a federal permit from something called the Federal Energy Regulatory Commission to build a pipeline. And the FERC decides eventually where it goes and where you can do the routes, and that's how you get started, and that's how you eventually operate your pipeline. Then it's subject to other federal restrictions and federal safety requirements and so on. So if you need this federal permission, then you're going to have to consult. Well, you don't do it as a group of investors or project proponents. It's actually the federal entities that are involved in the project. So that FERC, the Federal Energy Regulatory Commission, for example, based in Washington, D.C., it must consult with every tribe affected by a pipeline. In this case, the pipeline I described, Ruby, there were 86 different tribes that had interests in the route of the pipeline. They may have had, and often did have, reservations hundreds of miles away from the pipeline because that has been the history of the country. Tribes were typically forcibly removed to much smaller pieces of land and often far away from where they originally lived. And that is a tragedy in so many ways. And yet that's the history of our country, and it is what it is. And ultimately, the rights that tribes have as governments continue, even if they are no longer in that geographical place. They still have cultural ties, they still have spiritual ties, they still have historical ties. And so that's our law. So a statute like NEPA requires that there be consultation occurring. This picture I took was on Bureau of Land Management land, part of the U.S. Department of Interior. So Interior had to consult to do the right-of-way, the land rights to be able to build that underground pipeline. They had to consult with the same tribes in addition to what FERC had to do. The U.S. Fish and Wildlife Service has to give permissions if the pipeline construction interferes with, say, migration of sage grouse or other kinds of species. Again and again, those agencies must consult on a government-to-government basis with tribes. And it's not just language, it's not just lawyers' words. Tribal consultation is judicially enforceable because it has to be meaningful. Now, what's meaningful? Well, that happens in the courts. The courts decide what's meaningful. But what it means for the purposes of this presentation is that when an entity consults, like Mesa Verde National Park, with tribes on matters affecting those tribes, the park must do so in a fashion that's meaningful. They can't make decisions, the National Park Service, and then present them as a fait accompli to the tribes and say, oh, here's what we decided to do. We're going to tell you about it, and then we'll go on our way. The tribes have to have input into the decision. Their views have to be sought. They must have a chance to comment. Now, the agency, in this case, National Park Service, doesn't have to do necessarily what the tribal nations want. They could even do the opposite. Sometimes they do. But the point is that the consultation process must be meaningful. And if it's not, then the federal courts will invalidate it. So here's an example, just a recent one that was very powerful. On September 30th, 2015, an Obama-appointed judge, a guy named Scott Skabdal in Casper, Wyoming, he enjoined. What that means is that he stopped on a nationwide basis, not just in Wyoming, but over the whole country, a set of rules that the BLM had promulgated about how it would develop regulations for hydraulic fracturing or fracking. Fracking is the process, many of you know, you inject, a combination of water and sand and chemicals into an oil-bearing rock formation, and it releases oil and gas in a manner that you can then enhance the recovery of those resources. And this is a picture of North Dakota of a drill pad with multiple, as you can see, drilling rigs operating in a fracked basin, the Bakken Basin, North Dakota. And so think about the fact BLM had rules that it wanted to promulgate involving fracking, and they didn't go to talk to the tribes. And a group of tribes said, well, wait a second, we own oil and gas companies as tribes. We produce oil and gas, and we think that we should have different regulations on fracking. And frankly, the tribes that were involved thought the fracking rule was too restrictive. The tribes wanted more fracking. We're talking about the Ute Indian tribe, for example, in southeastern Utah, which is a major oil and gas producer. But there were other tribes that also intervened with the same position, said these rules are going to hurt our production of oil. They're going to hurt revenue for our tribal members. And we don't like it. And you didn't talk to us about it. And you presented this rule to us after it was done. You already wrote it. It was 104 pages, and we didn't get a chance to see it. So the judge agreed and said, all right, in the entire United States, this rule is now put on hold. And it was that way for more than a year. Eventually, the case went to the appellate courts, and the nationwide injunction was lifted. Those rules never were implemented. That was the second Obama term, and then President Trump repealed the rules. But it just gives you an idea of how powerful the right to consultation can be. Another example, even more recent, very quickly involved the FCC, the Federal Communications Commission. Everyone has heard perhaps about this transition to the so-called new services for your smartphones, the 5C services. And the whole idea is, or 5G rather, sorry, not 5C, 5G, the 5G service. And so it involves a system of very small towers that you put at regular intervals to support the new technology for your smartphones to operate and move more data more quickly. The FCC wrote its own regulations about this, and they did not consult with tribes adequately in a meaningful fashion, according to the appellate courts, the U.S. Court of Appeals for the District of Columbia Circuit. And this is what the court said. It's really interesting. Undertaking means that that's a federal government activity. In this case, the federal government was passing a rule that was going to affect tribes and towers located on lands that were traditionally tribal lands, not reservations necessarily, but lands where tribes had current interests. Because it doesn't have to be on a reservation, it can be anywhere. Both historic property and undertaking have specific meanings under a specific statute, the National Historic Preservation Act. To count as historic, such properties need not be on tribal land. In fact, they're commonly located outside tribal lands, may include tribal burial grounds, land vistas, and other sites that tribal nations regard as sacred or otherwise culturally significant. So even though the tribes don't own the land, they have a right to say, we want to talk to you about these places where you're going to put towers. We think some of them are sacred to us, and we don't think you should be putting a tower there. The FCC is supposed to listen to that before they make new rules. The most famous tribal consultation case and public controversy probably in the last 25 years was the Dakota Access Pipeline project. This project delivers oil from the Bakken Basin, from those drill pads I showed you in the picture before, down eventually to the Gulf Coast, but it's part of a large pipeline infrastructure that connects the Bakken Basin in North Dakota to the markets in the rest of the country. And it's a very long pipeline, almost 1,200 miles long, and it's a crude oil pipeline. So what's the federal trigger to trigger tribal consultation? Well, there's one long permit for the project, a linear permit called Nationwide Permit 12, but there's another federal, what we call a nexus or connection. There's a large reservoir. In fact, the third largest by water volume in the US is the Missouri River Reservoir of Lake Oahe, and it borders the Standing Rock Sioux and the Cheyenne River Sioux tribal nations. And right below that, 105 feet below the bed of the river is where the Dakota Access Pipeline goes. It's underneath the river, directionally drilled under the river. But in order to get a water crossing like that, you need to get a specific federal permit from the U.S. Army Corps of Engineers, because it's an Army Corps of Engineers reservoir. And there's also a right-of-way you need on the shoreline, although the pipeline's all underground. So that's a trigger for tribal consultation. And I point this out because the tribes challenged the route of the pipeline. It was not on their lands, but it was on their traditional lands and lands that had once been protected by treaty that Congress had then later rescinded the treaties, which they can do by statute. As I mentioned, they have this so-called plenary or absolute power over tribes. The tribes were not able to stop DAPL from being built, but they were able to delay the project. And the cost exceeded $750 million on what was supposed to be a $3 billion project, became a $4 billion project because there was not adequate tribal consultation, according to a U.S. District Court judge in the District of Columbia. And eventually the Court of Appeals out there agreed. And to this day, they're still litigating. That case is still going on. It started in 2016, and their tribes are still litigating with the pipeline company and with the federal agencies that were involved. Monica?
Yes, thank you, Troy. This is something that I'm sure most people followed in the news years ago. And as you say, it's still contested to this day. Do you have any updates on the situation with the Dakota Access Pipeline, otherwise known to most people as Standing Rock?
Yeah, it's been interesting because the tribes have wanted the flow of oil to be stopped, and it's 540,000 barrels a day. It's a lot of oil. And in fact, the pipeline's been expanded to carry more oil since it was constructed. But the district court was open to that and actually ruled at one point to shut off the oil flow because the tribal consultation was inadequate, and to do more environmental impact analysis, which the tribes wanted on whether it could leak, even, despite the fact it's 105 feet below the lake bottom, could it leak in some fashion or rupture? What would happen? The DC Circuit Court of Appeals has required additional environmental review, but they refused to shut down the flow of the oil. So that's the current status of it. It's changed, I can tell you, as someone who's worked representing tribes and also representing utilities and pipeline companies for many years on major infrastructure projects. It's completely changed, DAPL as the slang, completely changed the lay of the land of what we do. Tribal consultation was something people typically didn't think a lot about if they were in the private sector world. And now it's one of the first things you think about if you're planning to build infrastructure. Who's going to do the tribal consultation from the federal government? What role can the company play to support that? And tribes are much more attuned to the potential that they should not be bypassed in these discussions, that their federal officials need to step up for them. And so the terrain has shifted dramatically. We finally get to Mesa Verde. You probably wondered, would we ever arrive at the park? Well, it's important to understand that for a national park, there's going to be tremendous interaction with tribes in many instances. But think about Mesa Verde. This was the first national park ever created to recognize the role of human beings also with the landscape. And so that connection remains to this day. The ancestral Puebloans are the forerunners of other native people, the Zuni, the Laguna, the Yakama, the Hopi, and many others. So they're the so-called affinity tribes, but these are their forebears. There were other native people in the area. They weren't necessarily there, all of them at the same time, but the Navajo, the Ute people, the Paiute people. There were many people in what is now Mesa Verde National Park, living and hunting and gathering, and so there's a very rich history, but also current cultural connections, and there's the very deep roots of the cliff dwellings and their connection to modern civilizations that endure to this day. So you can imagine, are there federal undertakings? Well, yeah, it's a national park. Everything the park does is going to have some effect potentially. So there's constant tribal consultation going on. And I was very privileged to visit with the superintendent at Mesa Verde this last week, Casey Cook Collins, who's a phenomenal leader. And she had just returned from a tribal consultation when I saw her on one topic, and that's typical of our leaders in the Park Service. This is a major priority for them, and part of the policies that the Park Service and the Department of Interior require, rooted in the trust responsibility that we just talked about. Now, I'm going to give an example of one of these, a tribal consultation case study, and some of you are familiar with the Nordenskjold expedition, quote unquote. So the background for this is that in the late 19th century, especially, all these forced cessions of land that we have been talking about, and the concept of compulsory assimilation, that is to say, there was a man named Harry Pratt who ran a boarding school called Carlisle in Pennsylvania that was the model of this era. And his phrase was, "We must kill the Indian to save the man." And what he meant by that, he said, was we got to drive out everything that's native about a person and make them like non-natives, like white people of that era was the thinking. And if they can become Christian, convert, the actual federal law of the era of the 1880s in the original Code of Indian Offenses that the federal government promulgated, not only did it impose federal law on the Native people living on reservations, but it also, for the individuals, was requiring forced boarding schools. So you'd have to, send your child, or your child would be sent to part of the federal government system of boarding schools in many, many instances. And then in the curriculum was that they would have to assimilate. And eventually the idea was that the Native American-ness would disappear. This was the federal policy. The forced boarding school policy was the policy of the United States government until Jimmy Carter was president. So I want to call out President Carter, who actually ended that in 1978. There's a lot of good work that's happened in this field, but it happened really late from my estimation. It took until 78 to get rid of forced boarding school as a model. And we could do a whole webinar on the legacy of forced boarding schools. And then they also carved up reservations by Christian denomination. And so depending on the size of the reservation, sometimes whole reservations would go to one church. Sometimes a place like Navajo Nation, which is very large, the size of West Virginia, was carved up among 7 different denominations. By statute, by law, they would do the education in the boarding schools in those areas. So you had a specific enlistment of religious institutions to provide the instruction that young people received for the purposes of assimilating them. It was the normative view. And so part of this spirit of that age was that you'd collect Native American human remains and artifacts. And that seems maybe repugnant to many today, and I personally think is, but that was what many people did. And the idea was we got to save them because this is a vanishing American. Now, when Zane Grey used that phrase, he was, we think by all indications, he was not suggesting anything particularly negative by it. He was viewed in his era as a very, very pro-tribal, we wouldn't say tribal sovereignty, but someone who was had positive views of Native Americans in his day, in his medium of writing novels. And so when he wrote The Vanishing American, which I encourage all of you to read, and also the movie, if you've ever seen it, it's shocking in many respects, but it's also, for its era, it was actually a fairly progressive film in some ways. And the concept of vanishing was driven by this idea that as people assimilated, they would go away. They become something that they weren't. They would no longer be Native American, they would be American. That was the concept of the era. And that's something that chafed at Zane Grey. He was not a fan of forced assimilation, despite it being the dominant view in the media and elsewhere in public policy in his era. But that's the concept, is that people would collect things because Indians were vanishing. And kind of the height of this wave, in our part of the world, Mesa Verde is typified perhaps by Gustav Nordenskjöld. And this name Nordenskjöld, which is hard to spell and maybe hard to pronounce, it's interesting because if you've heard it before, you may never have heard of Gustav, but I think his father's name was Amundsen, but we'd have to look him up. But his father was the famous explorer who explored the Northwest Passage above Siberia on ships and was the first to do that a generation before. So his son had some health issues, and he had some money, and he came out to Colorado, and he began on his own with his own technique, such as it was, and enlisting others, he began to excavate the cliff dwellings at Mesa Verde. Now, this, again, was federal public domain. In fact, in his era, in 1891, just to make it really clear, Mesa Verde was part of the Ute Mountain Ute Reservation, which exists to this day. And I'm the outside legal counsel for that tribe. And so he was literally going on a federal reservation, recognized the reservation held by the Ute Mountain Ute tribe, and was digging up human remains and what we call articles of cultural patrimony is the phrase that's used, artifacts associated with burials. And so the locals didn't like this. They could see that, well, maybe we don't envision a federal role, but we certainly don't think someone should just show up here from some foreign country and start digging up these things and taking them away. If anyone's going to do that, that'll be us who live in the area. And so there were no laws, as it turned out. They arrested him. They put him in jail for a while in Durango, but they couldn't hold him because there was no way to under federal or state law. And so this led, by the way, to two things. The creation of Mesa Verde National Park in 1906 to protect it as a park. So it was carved out of the Ute Mountain Reservation. So there would be explicit protection for that place, and then a companion law that went with it. The Archaeological Resources Protection Act eventually was passed, and then we know about that from the late 70s, but there was a predecessor act called the Antiquities Act that was also passed in 1906, along with Mesa Verde's legislation. And it said you can't just come here and dig up things without a permit. You can get a permit, and maybe the Park Service will give it to you, or maybe they won't, but there has to be a process, because this is federal property belonging to all the people. Someone can't just show up and take these things. But that was after Nordenskjöld had his expedition. So this dashing young man, and that coat is something, Monica, that's, it's probably not appropriate these days, but, if anyone finds a coat like that, and it's, who would not want to wear that coat, right? Although in this era, maybe many wouldn't, but it's a magnificent coat. We can point out it's a very handsome coat that this man is wearing. So
I suppose so, but that also segues into a whole different webinar on, for example, indigenous rights to hunting, fishing rights, and whether it's eagle feathers or seal skin or walrus tusk. That goes into a whole nother segment on indigenous rights to the organic materials of the land and the animals.
An excellent point. And so that's, I think a sequel is coming. So, but what ended up happening was Nordenskjöld got his crates back to what is now Finland. It was Sweden then. Finland didn't get its independence until later. So the Nordenskjöld collection was in Helsinki for more than a century, and some of these artifacts were displayed, some were stored. So again, this lit a spark, and eventually we had a national park created, this incident of Nordenskjöld, and then the Antiquities Act, which applied to the whole country, the whole United States. For it didn't just allow for protection of resources in national parks. It also said that the president could create national historic landmarks. So this is the controversy over the Bears Ears. This will be another webinar I think we're going to be doing, since Andy Gulliford, our board member and distinguished historian at Fort Lewis College, is just writing a book about this. It looks fascinating on the Bears Ears. Basically, this Antiquities Act gives the president the ability by executive order to set aside areas that have a specific historic status. They can have prehistoric structures and other objects of historic or scientific interest situated on lands owned or controlled by the federal government. So if you have the federal domain out there already, a president can say, we're going to take a portion of this, we're going to take it offline for other purposes. And as they did at Bears Ears, it was Bureau of Land Management land, but then President Obama did an order, it became a national monument, Bears Ears National Monument. Then President Trump reduced it by 85%. Then President Biden has been restoring it to the Obama era limits. I will point out that the Obama era limits are much smaller than what the tribes wanted. And having represented two of those tribes in that process, don't be surprised if they're going to be seeking a much larger Bears Ears than the current status of the executive order that President Biden has just spoken to. Also note that you don't just create a national park, Congress does that. You can create a national monument using the Antiquities Act, but park status is even a higher status of protection, and only Congress can do that. So finally, as I mentioned, all of this led to a much more comprehensive law in 1979 called ARPA, and that says that even if you go on a reservation, like an Indian reservation, or if you go on any other status of federal lands that are not national parks, but any federal lands, you can't dig there and excavate things without a permit. This has been incredibly important in areas like the Bears Ears, San Juan County, Utah, outside the boundaries of the national monument, where there is a long history of rampant looting and other kinds of excavations that there's a whole industry based on it. If you're on federal lands, you need a permit, and I encourage you to look into that issue further, and that's something else that is of great concern and interest to tribes. Now, related to Nordenskjöld in its own way, and to, again, these are all triggers for consultation, is NAGPRA, another wonderful acronym, Native American Graves Protection and Repatriation Act. So NAGPRA is a 1990 law, And it says that tribes can do two things. One is that they can trace, there's a way for them to trace their forebears. So if they're linear descendants of human remains that are in museums, anything that has a federal funding or federal status of some sort. Typically, every major museum system has, like the Field Museum in Chicago and the Smithsonian has some federal funding, right, or they're federal institutions. There's the ability for tribes to say, we're affiliated with those remains, and we want to have them repatriated to us, and we can then have them reinterred or otherwise can address their status. So that comes out of museums and archives and so on. But there's also a second part of NAGPRA, which deals with inadvertent discoveries of human remains. And so you can't, if a grave is found, for example, somebody is out and excavates a site and there are human remains, you call in law enforcement. If they're more than 100 years old, then it becomes NAGPRA protected if it's on some sort of federal land, not so necessarily for other types of land, including private property. But many project developers will treat NAGPRA as applying to everything because the era of wanting to collect human remains is of limited interest to most people. So the idea was that if you discover human remains, there's an obligation on federal lands, there's an obligation to find those affinity tribes and then repatriate them, and the tribes have the right to have consultation occur with the protocols to make sure that these excavations take place so they can witness them through tribal minders and others on scene when excavations are occurring. And that's kind of the standard practice for doing projects in both government projects and private sector projects on federal lands. And then there are inventories that have been created. This is a massive law. And I've represented so many different interesting clients on this. It'd be fascinating to just get into this sometime, including major private university systems, including helping tribal members. I've done pro bono or free legal services to families trying to get remains repatriated to tribes. They go to their tribes, the tribe makes the request, and then I try to get the remains out of certain museums. One from the University of Arizona not long ago, which had some. You'd be amazed at the number of places in our country that have dozens or sometimes hundreds or even thousands of human remains. I used to be in Colorado state government. I was on the governor's cabinet when Bill Owens was governor. We, at that time, the state archives was beginning to do its repatriation under NAGPRA. It's all been accomplished since then. But we had several hundred human remains from the Sand Creek massacre that the state of Colorado had in its archives. And so the tribes that were terrorized by the Sand Creek massacre in 1864 were able to obtain those and then have them reinterred in a place near the Sand Creek historic site. So Mesa Verde, you can imagine this is a big issue because think about potentially the number of human remains and associated items that have been affected. And Nordenskjold really is part of this. But as a matter of official policy, it's not law. If these items go overseas, there's no ability in NAGPRA to get human remains back. You can't go to Finland and say, NAGPRA, you must repatriate them to the affinity tribes in the United States. That the law doesn't say that. But as a matter of U.S. policy, we've had that on the books since President Clinton, and actually since President Bush 41. We've had it, and it's been implemented consistently. And it was actually during the Trump administration that this matter came up, and there was an effort where President Donald Trump raised directly this issue with the president of Finland as part of other issues that were being discussed, including whether Finland would join NATO and what that might look like. There was an interchange between Donald Trump and Sauli Niinisto to talk about, hey, what about the Nordenskjold collection? Can that be repatriated to the United States? And it worked. It actually worked. And kudos to the people in the State Department, especially, who supported that, and to the tribes that advocated for years to get that done. This was a priority, especially for those affinity tribes. And so in October 2019, there was an agreement made as these two men got together. And so what happens? Well, there was a lot of consultation that occurred between the tribes that have connections are the descendants of those who were originally buried at Mesa Verde, and then also the other tribes I talked about too. They also have consultation rights. The Navajo, the Ute people, the Paiute people, Shoshone people, who are in that area and have connections to this day, but we're not genetically affiliated with the ancestral Puebloans. There was consultation with the park. What would happen to the remains? Who would handle them? How would they be prepared for shipments? How would they be witnessed? Who would be able to see what went into the crates? And then how would they be unpacked? Where would they be reburied? Was reburial the right way to deal with it? Well, eventually there was a coalition that decided it would be reburial. And it included the Hopi tribe, the Pueblo of Acoma, Pueblo of Zia, Pueblo of Zuni. There were others. But those remains on September 13th, 2021 were repatriated. They had been repatriated and they were reinterred. So there's a place that we can't talk about. I wasn't there, but there's a place that the public does not know about, and that's where they are now. That's where the 20 ancestors that were returned pursuant to this 2019 agreement between the two countries were reinterred at Mesa Verde. And you had the U.S. ambassador to Finland was present, Ambassador Pence. You had members of the representatives from the Finnish government, from the museum in Finland, and there was a process for escorting these remains back. And there were ceremonies that were performed on site. And I wanted to just point out that there was donated air transit, because there's quite a bit of, there were associated items and so on. You had a number of crates that had to come back. And Finnair and American Airlines, they donated their transportation services. But the Mesa Verde Foundation, so thanks to all of you who support the work of our wonderful foundation, please join us, become an affiliate member, support our work, help us support the park. We're not a political body or something. We just raise money to help the park. That's all we do. This is a great example. There was no money anywhere to pack up these remains. And it's an expensive process, believe me, and to have them adequately shipped in a safe manner. So we put in money as a nonprofit foundation to help with that process. That was our contribution as a foundation. So that's what I have, Monica, and I'm glad to take questions. And I appreciate everybody being so patient with me, and so does Athena, the 9-year-old English Springer you see in this photo. Thank you.
Oh, how sweet. Well, thank you, Troy. This has been extremely enlightening, and just the stature and the scope of your work that you do. Not only that, but how mindful you are on how cases impact people and communities. I think above everything else, that's what, strikes me the most, is just how you consider everyone, whether it's the nation, tribal sovereignty, the community, families, or the individual themselves. So thank you for all the work that you do. And I also want to mention that you were adopted ceremonially into the Navajo Nation. Could you tell us about that?
Yeah, it's interesting. I'm not Native American, and I've had my genes tested, so I can tell you I'm Native American. There's no genetic link there, although I am something like 12% indigenous Siberian. I'm not sure when that happened, but it is interesting. It was mentioned that I'm president of the Navajo Nation Bar Association, and I'm very honored to have that role. I've been an active member for many years, and I'm the first non-native to serve in a role like that. And the answer for that is when you're asked to serve, and I was asked to do it, and I'm finishing up my 4th year. And I would just say that maybe it's because of the point that you made. My father came from Egypt with $100 and to the United States, and was really glad to have a place to come over here as a student in 1957. And we didn't have any. Of course, I was a gleam in his eye, but there was no money or anything for his journey. He came all by himself. And as a person who is Egyptian, it's a pretty remarkable thing to learn about these issues, because I can tell you that watching Egypt has been fascinating. They have learned so much from the repatriation movement in the United States and Canada and elsewhere. That has fired up a lot of Egyptians. What you have seen is that while the British National Museum, for example, and the Berlin Museum have not been willing to turn back the things that everybody knows about. There have been repatriations of human remains that have occurred, and it is really interesting to see how the treatment of human remains has changed within the archaeology profession in Egypt, and so the influence of Native American advocacy in this country has had a big impact, I think, on other countries as well.
Well, thank you. It's interesting because with NAGPRA, it's really a process. Do you think there will be anything to expedite a NAGPRA process with an institution and tribal nations or communities or descendants?
It's a great question, and you're more of an expert than I am. I mean, and many know Director Buckle, in her leadership role. She's in charge of a museum collection that these issues come up all the time. There's constant interface going on, and when you have a statute that's as powerful as NAGPRA, I mean, a couple of things. One, you have to explain it to people because often they don't understand, why would you ever have this? What difference does it make? And so there has to be some education. Different people have different points of view in terms of religion and spirituality and whatnot. And it is an important point of view for many Native American people and their governments to be able to have control over artifacts associated with burials and human remains. There's much of a thought, it's not universal, but there's a very strong thought about how people need to be back in the land where they were taken from. They're supposed to be in that place, and that place is a sacred place because they're there, and it's wrong to take them away. I think many cultures, maybe most cultures, deplore grave robbing in one form or another, but it goes far beyond even that to a concept of place and land. And so the concept of having a NAGPRA that is even more inclusive, for example, internationally, is much talked about, and many people dream of it, and some are working for it, but it's going to take some more time.
Okay, wonderful. Well, thank you, Troy. And I'm all about harmonizing situations and circumstances. And what's the Navajo word for harmony?
Hosho. And Hosho is a sense of, and my Navajo friends are listening are just be like, oh my gosh, his pronunciation. So, but it's hard to translate it. But there's a sense of being in a balanced set of relationships with the natural worlds, with the inanimate world as well. But in all your relationships, you should be in some sense of balance. It's an interesting point of view. The concept of there is good and evil in a dialectic, and there is good and evil. There's no debate about that in the Navajo way. There's good and evil, but they exist in a duality. There's not a time where you'll have all good and all evil that'll be sustained. You have to have a balance. Your point is to try to balance between them because they're inevitable. And so it's, in that sense, it has some conflict with some Western views. But I can just tell you that it's very interesting to think about matters like this. And it's important when you have an issue like tribal consultation, because you're going to be listening, as I know you have many times, you're going to be listening to lots of different points of view. And many tribes have different points of view about how things should be handled and addressed. The Navajo society traditionally is a matrilineal society, and women are the heads of the household. And the household means everything connected with the family. The traditional Navajo divorce, which is still occasionally practiced on the reservation, is if you are done with the husband, you leave his belongings outside the house. The old days, the hogan. And that is under Navajo law, that is definitive for divorce purposes. If the wife says, there's your stuff, you go back to your parents. There's not a reciprocal right for a man to say that to his wife, oh, now, I'm going to put your stuff outside and you need to go. That doesn't exist in Navajo law, but the other relationship does, because in the Navajo way, women they run the family. They're in charge of the greater family and the survival of the family. But everyone is part male and part female. Everyone is, as we're right and left-handed, we're also male and female. There's a duality going on. And so your purpose is to try to be able to balance it. And it's interesting because these views come up at consultation, and that's just one of many countless illustrations that come up. And so that a superintendent or another leader in the Park Service will have to consider these things. And so when a tribe wants access to a site, for example, we need to go to a site for some purpose. The park official has to decide, well, we have a general policy about how we protect things, but the tribe has an interest in being able to go in for its purpose that's different. Can we accommodate that? And federal law broadly accommodates religious exercise and spiritual practice in a series of federal statutes and just also court decisions. So, and that's something that makes consultation vibrant, because these issues come up constantly. So many of them are access. Different tribes want access to different things where they traditionally had connections and still have connections, but it's not, quote unquote, their land anymore.
Well, thank you. Well, why don't we get into some of the viewers' questions? We have a comment and a question from Chris Barnes. This is an excellent intro to Indian law. I'm interested on your insight on the current movement to evolve, quote unquote, consultation into actual transfer of certain national parks and wilderness areas back to Native peoples for ownership and management, i.e. land back.
Yeah, that's a really good question, whoever asked that, and a very timely one. So we've got some different status in the park system that's unique. Canyon de Chelly, which some of you have visited, is within the Navajo Nation, and it became a national park, I believe in 1934. I have to check that, but it has a status where it is in dual management by the Park Service and the Navajo Nation. And it's unique within the park system. So there are some models, and that I mentioned that one because it's an old model. Navajo treaty had protected Canyon de Chelly, the Treaty of 1868, and so the nation, or the tribe as it was known in those days, was against this becoming a national park. And so the compromise was, okay, we will co-manage it. And so it's a unique situation within the Park Service. There are joint management agreements in the Badlands of South Dakota, for example. There are different places where this has occurred and is beginning to occur. I can tell you, representing the Ute Mountain Ute tribe, I mentioned it was all part of the Ute Mountain Ute Reservation, which is headquartered in the small town of Toyac, Colorado, which if you're on the right part of the mesa, which is a remote place to be, you can look down and see Toyac below you. It's down on Highway 491 on the way to Shiprock, between Cortez and Shiprock. But, there is actually, when you're on, you're up on the mesa as a tourist or a visitor, and you're on, driving down in the loop of Wetherill, you actually go into our reservation, the Ute Mountain Reservation. You don't know it, but actually the line was drawn in a way that you actually end up on the reservation boundary. So the Congress didn't have the line properly drawn as to where the park was supposed to end. You actually are on reservation land. So you have had a series of relationships over the years where the Park Service and the tribe have come up with, well, we can have some vendors there, we can have some interpretive exhibits. There are things that can be done. But the tribe has been interested at different points in time in managing all or part of the park. They have their own tribal park that's the continuation of the mesa to the south. And if you've not ever seen that, I encourage everybody to go to the Ute Mountain Tribal Park. You can only go with a Ute guide. It is Mesa Verde with no restoration or minimal restoration. And you're climbing up and down ladders and you're seeing, ears of corn and pottery all over the ground. And it's a magical place, very different from the Mesa Verde experience in most of the park available to most visitors on a regular basis. But the problem with this, though, is that there's a federal law, that talks about the mission of the Park Service. And it's not a wilderness area. Park Service is a broader mission for the public, setting aside areas for the enjoyment of future generations and making them accessible to the public, very broadly accessible. And so the Park Service is constantly dealing with these balances. And I know we'll have some separate webinars that discuss that. But federal law is pretty clear about the mission of the Park Service. And tribes are their own governments, and they have their own mission. They have their own constituents. And so, what I see happening are more joint agreements to do things, projects or areas, that are maybe co-managed. But I'd be surprised if there would ever be a full-blown transfer. It is possible, but the tribe would be assuming a much broader obligation. And there are some tribes that are willing to try that. But the challenge for tribes, one major challenge is money. Federal parks are appropriated a certain amount of money to do this. Would that portion of that appropriation go away from the park to the tribe? That can be done under federal law, but would it be enough? Would it take away or diminish the mission of the rest of the park? So there are a lot of practical issues with this, but I think it's fascinating, and I know there'll be more and more of these kinds of agreements. We'll probably see it play out the most in Bears Ears. That's where I think we're going to see long term. Maybe we could have a model of lead tribal management and see how that works in the national monuments. That's been, that's what the tribes certainly want, something like that.
I think you hit it on the head, Troy, with just the aspect of funding and the financial means to keep things in operation. And that falls back to NAGPRA. So many institutions obviously want to do the right thing and what's ethically responsible. However, it comes down to funding, because institutions and organizations, if they are going to repatriate, they have to fund the entire process.
Yeah.
And whether it's tribal consultation, you pay for the travel, the arrangements, and their stay and so forth. So there's so much more that goes into it. You cannot just say, oh, by the way, we have something in our archives, it's affiliated with your tribe, and we're just going to send it out, So it comes down to funding at the end of the day. Next question is from Stephen. If Indian nations are sovereign, then why does the Sovereign Immunity Act require tribes to negotiate gambling compacts with states?
Well, it's another great question. So I mentioned these are sovereigns within a larger sovereign. Congress has what's called plenary power or absolute power. As I mentioned, they can terminate a tribe. They can say, you no longer have a reservation. You no longer have federal recognition. Your tribal members are no longer going to get health benefits from the Indian Health Service. And Congress has done this many, many times. I mentioned 100 times just between 1953 and roughly 1962. So that plenary power is the brake on all of this. Congress can decide that it puts limits on tribal sovereignty. So, for example, tribes do not have criminal jurisdiction over non-Indians at all, except for a narrow category of domestic violence cases through the Violence Against Women Act amendments. That's a great example. There's been a limit placed. And this is another limit, Indian gaming. The Supreme Court recognized Indian gaming in a decision called Cabazon, and said tribes have this inherent power. Congress has never said they don't. Then Congress passed a law in 1988 called the Indian Gaming Regulatory Act during the Reagan administration, the very tail end. And that law says, okay, we the Congress recognize that tribes can engage in these kinds of gaming, not all kinds of gaming. And they list them. There are 3 categories. And by the way, the only way a tribe can engage in gaming is if they do 2 things. One is that they have to use the money produced for core government services. Now, many people don't understand that. If people are watching The Simpsons or something and getting their education about tribal casinos from Homer Simpson, they may not understand that all this money that comes from the relatively few tribes that have casinos, and only about 30 are very profitable. And those that are profitable are hugely profitable, I might point out, or can be. I represent Hard Rock worldwide, which is owned by the Seminole Tribe of Florida, and it's the 7th largest commercial landowner in the United States. So there are some tribes that have built gaming empires. They have, more than 350 casino properties around the world. But that's not the typical situation. There are about 30 that have made a lot of money in gaming, another 30 that do well. There are about 150 or so tribes that have casinos. Most don't. I mentioned, 574 tribes. Most tribes don't have any access to casino wealth. And so, just kind of keep that in mind, is that Congress said, number one, the money has to go to government services. So if you have Indian gaming, you've got to recognize that. And then the second point is you have to be able, the Congress has said, to not just use the money for that purpose and not just limit the games. You have to have what's called a compact agreement with the state. The state has to enter into an agreement with you, and the state can demand a revenue share. And there's no limit on what that share is. And so I am pleased to report, as legal representative, representing 2 of the tribes as an outside counsel, one of the lawyers, Ute Mountain Ute and Southern Ute in Colorado. We're the only state in the country that has no revenue share. Colorado we don't make the tribes share any money with state government. They do share money with local government, but not with Colorado state government. They were deemed back when Dick Lamb was governor long ago. May he rest in peace. He just passed away last year. But Governor Lamb said they're just too far from Denver. They're 340 miles and 400 miles respectively from Denver, and they don't get many state services. Why would we take money from them? But this is an issue for many states, and it's always contentious in some. So IGRA, Indian Gaming Regulatory Act, is an example where Congress said, yeah, you have sovereignty, we'll recognize it to a point, but then we're going to also demand you the tribes, limit your sovereignty. And in this very important way, tribes can only spend money on certain things, and then they also have to have a gaming compact agreement with the state. And so there's a timeline in the statute for how that works. Oftentimes there are fights. I represented the Pueblo of Pewaukee in New Mexico when it was fighting with New Mexico. They didn't have a gaming compact for a long time. Then they had to figure out, okay, now that we have a compact, how do we pay for the fact that the state wasn't getting its revenue sharing while the disagreement was going on? So these are all infringements, if you will, on sovereignty that Congress has decided are in the national interest.
Well, thank you, Troy. It's amazing. Are you able to speak to any projects you're working on at the moment or anything upcoming you have going on in Indian country?
Well, there are a number of things that are interesting. And thank you for that. Just real quickly, I mean, one is I'm working for Xcel Energy right now, and they have a project called the Colorado Power Pathway, which is their build out of transmission infrastructure on the eastern plains of Colorado, from Denver basically out to almost to Kansas, and then down south, so that it eventually makes a big rectangle. It goes south of the Arkansas River and comes back south of Pueblo and then comes up the Front Range. These are new transmission lines. And as wind and solar continue to be developed out there, this is the way that Xcel sees its transition to being able to have the transition from coal and eventually natural gas to wind and solar and alternative resources. So in that area, there are, of course, many tribes that have interests. And so that's an example where I'll be representing a utility, as I often do in the tribal consultation process. They're not a party to consultation, but they can help provide information. They can, some cases they provide resources to tribes, and they have to provide information. And sometimes projects they might be modified as a result of the consultation between the two governments. That happens quite a bit. So I'll be involved in that. I have a number of projects like that. I've also got a carbon sequestration project, which is really interesting, in 5 states in the upper Midwest, where we've got taking the carbon dioxide from about 40% of the ethanol production in the United States. When you make ethanol, you take corn, you get water vapor. When you make ethanol out of it, you get ethanol. You get, as byproducts, you get water vapor. You get distiller's grain, which is used mostly for livestock feed, but also for distilling. Bourbon, if you guys like bourbon. I know David Nagler, our board chairman, if he's listening to this, is probably.
I always like distillery taste testings and tours.
Just teasing, David. So, and then you get a pound, it's per pound, you get a pound of carbon dioxide greenhouse gas emission. Well, this project would capture that carbon dioxide in a series of small 4-inch pipes that go to the facilities, and then they eventually transfer the carbon dioxide, and they inject it underground in a rock formation in central North Dakota, where it's supposed to stay for 20 million years. And you get federal tax credits if you can do that. You get 50 cents a ton on the federal 45Q tax credit. So we have signed up more than 50 ethanol producers, and we're going to build a pipeline project in 5 states, and that's what I'm working on too. And there are 68 tribes in that area, and there is a lot of interest. And none of the projects on tribal lands, but 68 tribes have the rights I described in these lands, and they're indigenous lands where the pipeline will go. It's a great project. It takes the equivalent of 4.7 million, I believe it is, automobiles off the road. I mean, the equivalent in emissions, and it just puts it underground, and that carbon dioxide slowly breaks down over time. It's not used for anything else, it's just stored. That's what carbon sequestration is. And if anybody's interested, the project's called Midwest Carbon Express. And you can find it online. You can Google it and find it online. You can also read about how we're supporting tribal consultation. There's information there as well. So just some examples. There are a lot of other projects too, and doing interesting work for tribal governments as well.
Well, it's something when you speak to working with 68 different tribes, just the work that goes into it, and 68 different viewing opinions and thoughts and outlooks and perspectives. I can't even imagine.
It's a very interesting, if you like people and you're interested in history, and you're also interested in the fact that ownership is, so much of our society is ownership is everything. Well, there's another perspective too. I'm not diminishing ownership, but there are other points of view. One point of view is that you still have rights if you don't own something. And, we sometimes err so much on the ownership side. We just have to understand, if there's a place that is sacred to somebody's worship, you wouldn't run a pipeline through the center of the Sistine Chapel, or through any of the great mosques, in Istanbul or anywhere else, or through a synagogue. You wouldn't do those things. And, you got to think about, whose church are we talking about, quote unquote. And there for many years, there was just a complete willful, I think, disregard or just a lack of interest that Native people worship too. And they worship in their own ways, and they need to be able to worship, and they have their cultural ties and their way of life respected. And that the whole promise of our country was that we wouldn't favor one point of view over another. That was the whole, the promise, the aspiration of the United States. Now, and I mentioned Indian people weren't part of that consent and part of that bargain, but we all are, citizens of this country now in this era. Indian people on reservations didn't get their citizenship in the federal government until 1924 by an act of Congress, but they have it. And in many states, by the way, they didn't get it until much later. Colorado, not until 1936.
Wow.
Nevada, not until 1961. I mean, a Native person living on a reservation in Nevada didn't become a citizen of Nevada until 1961. I mean, it's an interesting history. But now everybody's a citizen of their state. They're citizens of the federal government. And if they're a tribal member, they're a citizen of their tribe. And so, we're not supposed to be making distinctions that are punishing people. We're not supposed to be establishing a state religion. And we're supposed to protect free exercise. We're never supposed to degrade religion or spirituality as a concept. That concept is foreign to us. We're supposed to have that balance between not establishing and allowing free exercise.
Well, thank you, Troy, for helping to further protect sacred sites, across Turtle Island, because as you said, it's not necessarily a physical structure, but it is revered, it's sacred, and utilized in ceremonies to this day for peoples and communities across Turtle Island. We have so many wonderful feedback coming in, great presentation. Troy, I want to give you any closing thoughts. Anything you'd like to share?
Up here on the mountain above Morrison, Colorado, the sun gets low, and then eventually I'll turn completely then everything goes dark. So that's good.
Well, before we close it, weren't you just at a marathon race? Because for viewers who don't know, Troy's a marathon runner. You were just at a Navajo Nation race this past weekend.
Well, that's very kind of you. I am on the board of Navajo Yes, and you can Google Navajo Yes. We're a nonprofit Navajo corporation, Navajo run, Navajo created, and it has many big projects for young people and for people of all ages. And one of the things we do is we run the Navajo Parks Race Series, which you can also Google. Sign up for one of our races. We have mountain bike races that are absolutely incredible. And we have running races, ranging from, 5-kilometer races to marathons and ultra marathons around some of the most amazing places on the Navajo Nation, including places like Monument Valley, and we have a race at Navajo Mountain or Not Sasan. I just was down in Shiprock where we have a marathon. Our biggest race of the year is we have a marathon and a half marathon. And if you've been to Shiprock, New Mexico, you can look up and see that marvelous step at that Sibda is rock with wings. And that's, you run out there, you run out to it from the town, and then you run back. And you run closer to it if you're running the marathon and if you're running the half marathon. But yeah, I was just out there last weekend, and finally we're starting to see the restrictions end. Just as a serious note, we've had such a hard time. I mentioned Navajo Bar Association, we had 650 members roughly, but we had 15 die of COVID-19 in a very small organization. And we had 3 additional members die because they could not get organ transplants from the Indian Health Service. They weren't doing them on reservations for a long period of time because of COVID. They just didn't have the capability, they said. So we had, we lost many really wonderful people. And, the nation, as with so much of Indian country, per capita suffered much more than any other part of our country. Reasons for that we're just beginning to understand. Some are obvious. The lack of clean water is a big deal for many people. We have 35% roughly of our population has no running water. And you were talking about 300,000 people that are living on an area the size of West Virginia, and a third of them don't have running water. Many don't have electricity. About another 20% or so don't have electricity, 15 to 20%. But then you have multi-generational housing. Housing's totally inadequate. So you'd have families together, multi-generational. And then finally, I've been working, you asked about projects. I'm working now on the Navajo fiber optic project. And it's so exciting. It's privately funded. It will link in its first phase, Phoenix to Salt Lake City directly through Navajo. And it's the internet backbone. It's the full-blown internet backbone, fiber optic backbone. And you'll be able to plug into it at all the major points at Navajo. The Navajo Tribal Utility Authority and others will plug into it. They can finally have this good quality internet as the rest of the United States. And eventually we'll have, the rest of the routes in many parts of the Navajo Nation, where we have 2 other later phases of that fiber optic project, one from Los Angeles to Dallas and one from Tuba City, Arizona to Denver. It'll go all the way up to Denver that we're working on. And I mention that because, when we shelter in place during COVID, we're not Navajo people. How did they do it? Well, they don't have internet. There's 91% of the people in Navajo don't have internet. So I want to say it again, 91% don't have it. Sufficient to be able to do any form of video or even reliable voice. So you've got kids there, right? In fact, the median age of the United States is about 38 years old right now, but in Navajo, it's 23. You have a lot more kids there per capita. But if you were during COVID and you're at Navajo, you don't have, you can't go Zoom to your school. So you're in your multi-generational home with your, perhaps a parent or 2, a grandparent, maybe an uncle, maybe an elderly great-grandparent. I mean, that's the reality of the lack of housing on the reservation. The median house has more than a dozen people in it. And so you're in a very small space, you're sheltering, you don't have the ability to do internet. And the only thing that they could do really was put hotspots around the local government centers. So if you have the money and you can drive out, 30, 40, 50 miles, you can sit in a parking lot outside a chapter house and you can do your homework. That's what we saw, or you'd have to go off reservation. So that's the world that Navajo and many other Indian reservations Native people have had to deal with. In this country, we don't think about the fact that we've left people behind. We have a trust responsibility to them. I hope everyone got that out of this presentation. We do not honor the trust responsibility. And my only political statement of the day, we just don't, we don't honor it. So, that's a great example. How could it be that, well, they don't have internet? Well, aren't we supposed to be protecting them? We took the land a long time ago. Aren't we supposed to be having this balance? Well, no, because Congress is in charge and Congress has done some good things, but they've neglected people for a very long time. So that's my only small p political message. So.
Yeah, well, it's a needed message. The digital divide, like you said, everyone was left behind, and how many children, youth suffered the fact that they weren't actually participating in school because of the virtual curriculums. And I'm just happy to know that Navajo has opened up a bit more. Things are doing better. It's a tremendous loss, losing elders, wisdom keepers, and something that knowledge that's so inherent to the survival and resilience of Native culture. So it's been extremely sad. However, if anything, there's always a metaphor and a lesson learned.
Well said. So thank you very much for the chance to be with everybody.
Well, thank you, Troy. It's been such a pleasure, and I'm just so grateful that you gave your time. You're always busy en route, traveling to a different location, so thank you.